Divorce is one of the most challenging transitions in life, and without the right guidance, it can quickly turn into a disaster. Welcome to Dodging Divorce Disasters, the show that helps you navigate the legal, financial, and emotional pitfalls of divorce before they happen. Each episode, we sit down with top professionals in the divorce community to hear real-life war stories, cautionary tales from the trenches of divorce. But we won't just leave you with the horror stories. Our experts will break down exactly what went wrong and, more importantly, how you can avoid making the same mistakes. Whether you're in the early stages of separation, deep in the process, or supporting someone through it, we're here to help you move forward with clarity, confidence, and fewer regrets. We're your hosts, Lori Hawkins and Pam Abarashed. We are local experts in the areas of real estate and lending, and we're so excited to be sharing these incredible professionals with you. Let's dive in.
We are thrilled today to have Chris Osborn with us. Chris, thank you so much for being here today with us.
Thank you guys for having me. It is a delight to get to see your faces and chat with you guys for a bit.
Perfect. All right. I am just going to let you kind of introduce yourself. Tell us kind of which areas of divorce you kind of do, maybe the counties that you practice in, the name of your company, and we'll take it from there.
Sure. So I have, since 2016, I have been the principal of the law offices of Atty Chris Osborn. That's my law firm. Originally, it was called Osborn Conflict Resolution because that was what I was trying to be focused on. And was doing a broader range of different kinds of cases. I have a background actually before that in real estate litigation, business litigation, some employment litigation, a lot of real property related litigation. And so I wanted to try to signal, hey, I'm here to try to be a problem solver, to resolve conflict, and really did not expect that I was going to be getting into family law. But I got trained in a method called collaborative family law that we'll talk about. And that led to me actually sliding over into family law. And because I got trained in that method and met some really great people who were practicing family law. And then in the last year or so, I've actually I handle more cases than just collaborative cases and mediation. So my firm now is called Osborn Family Law. And that's more the business moniker that we use and the website that we use. So, but it's been sort of a little bit of a backwards, unusual journey to embracing my calling as a family lawyer. It's only been in recent years that I'm like, this really fits. I really enjoy this. I don't enjoy what people are going through, and I'm not happy for their suffering and their difficulty. But I really do enjoy getting to be kind of a guide and somebody to help them navigate through that, and hopefully make it less painful than it could be.
Right.
And and county-wise, I practice. I'm based in Charlotte, and most of my cases, I would say, are in Mecklenburg County. But I also handle cases in the surrounding contiguous counties: Union County, that would be Monroe; Cabarrus County, up in Concord; Iredell County, and Gaston County.
Okay.
Those are the main counties that I've got cases pending and have been to court there. Would I go farther? There's some local aspect. It's helpful to have people, be practicing regularly in front of the courts that you're taking people in front of.
Okay, Chris. So our whole purpose for being here is to learn about your craziest divorce story. So we want to hear about the story and also what our listeners can do to potentially avoid that same problem coming up if they are going to be going through this process as well.
Sure. So I would say one of the craziest divorce stories that I've navigated was particularly, now, is it helpful if it's around child custody? That was sort of what I saw get really train wrecked. I know that's not necessarily the areas that you guys get involved with, but
no, this is whatever is your thing.
Yeah, if you caption it as the craziest, I would say this was one of the most difficult and challenging. I got retained to represent a father who had a split custody arrangement with the mother and his ex-wife. And they had battled through, before I came along, they had done all their equitable distribution, child support, alimony, spousal support, that sort of thing. By the time I got involved, they were battling over custody and child support for two reasons. One, the father had some periods of unemployment. He actually worked for one of the banks here in Charlotte. Mom also worked for lending institution or something like that. They both had pretty good jobs, but Dad had some significant periods of unemployment through no fault of his own that were just the market was down, and banks downsized, things like that, and they had both a I'll call it a regular custody and child support action in family court. And at some point in time, the mom had taken him to child support enforcement court also. And the reason that's important is because the child support enforcement court kind of operates on its own timetable and its own world. The different judges sit over those cases than do over the family court cases. And the problem that had happened by the time he came to me was when it came to child support, there had been multiple court orders that were entered in the regular case that altered custody and altered their arrangements of how much custody they had. And they even had, in that case, the court had issued some rulings that had modified his child support obligation for different periods of time. Somehow, that didn't all get communicated over into the child support enforcement action. And so the child support enforcement action is usually run by the county, and the county just looks at, here's what you owe. We've calculated up. If you don't have work, you should have work, etc. And they had him down for an arrearage of about $43,000. I mean, it was a whopper. And he came to me and he was saying, look, there are times that the court, the regular family court, had reduced my child support obligation to $300 or to $50 because I was out of work. And then it should have come back in again, or we changed custody. And none of that had been communicated or brought into that child support action. So I was just trying first to help him clean up, what is his arrearage actually? Could he possibly owe this much? Or if you paid attention to all the times he was out of work and the payments he made, reduce that down. And that was a big mess. But what it was layered on top of, this is the crazy part, was as soon as, like literally, the ink wasn't dry on the judge's signature awarding the parents 50-50 custody. He had 3 kids. One, I think, was maybe almost a teenager. 2 were young teenagers. The ink wasn't dry on the judge's signature before the mom starts documenting every single thing that he does that she says was out of compliance with the court order. Like right out of the gate, he was 3 minutes late for ballet practice, or he made me pick him up from ballet practice one time and it was supposed to be his time. And she was tracking every single thing, and she filed a motion to modify the custody arrangement immediately, basically, and brings all of these. And I think she may have filed one that kind of got dismissed because it was way too soon, because the court can't modify a child custody arrangement until you see over some time, how does it work? How are things going? So eventually enough time passed, and she filed a motion to modify that listed, I think, 17 kind of allegations of dad isn't doing this and dad isn't doing that. And I remember being somewhere I forget how I met this gentleman, but I started representing him, and we're going to try to, just defend against what mom is doing here. And I, was helping to kind of focus in, okay, what are things on here that the court's going to care about? What are things the court's not going to care about? And thankfully, we had a very good judge, Tracy Hewitt, who's not on the bench anymore. But she read through the list and she said, okay, Mom, there's a lot of this is y'all going to have to figure out how to get along and co-parent, but of your 17 things, there's about 3 here that I have some concern about, that I want to know more about, because they involved some kind of either inappropriate conduct or the child getting in trouble or things like that. But the rest of it is, I'm sorry, this is just, you're being too microanalyzing and all that. And in that case, I can't remember if we asked for it or if it had happened already, but we had a guardian ad litem appointed for the kids, because this couple was so high conflict. They were just, because my client had mostly conducted him well, but he had fired some shots back as well. And he had said some things and kind of gotten into the mix. So Mom was clearly being over aggressive, but there are times he had communicated in a way that wasn't helpful for him either. And so it was one of the ugliest, just pitched battles that I had ever seen, especially at that point in time. And we ended up having multiple contested hearings. One, they fought over, Dad wanted to take the kids out of town, out of the country to celebrate a grandmother's birthday. The mom wouldn't cooperate in getting passports. Then we got a court order that said she had to let him get passports. And She then signed it, like in a way, signed whatever form she was supposed to sign in an illegible fashion. And it was barely, you couldn't even read it. She had to, come back and be made to do that again. Literally at one of the hearings, the court said, look, there's a place downstairs where your signature can get notarized. Go down and sign it. Get your signature notarized right now in the self-serve center in the courthouse. And on the way there, she is like yelling at her lawyer, not me, yelling at her lawyer, full volume. In the courthouse kind of has some echoey, areas. And she's just saying, this is conspiracy and you and his lawyer are in on it, the judge is in on it. And she's just, wreaking havoc. I felt so bad for her poor lawyer, just along for this ride. But anyway, we ended up kind of having a contested hearing. We defeated the motion to modify. But at the end of it, the judge said, I'm going to talk to you parents right now. And let me tell you something. She said, your kids are great. Your kids are remarkable given all the problems that the two of you have given them. You guys are the problem. And you're going to keep coming back here unless you figure out how to do something to not keep pushing each other's buttons and, refighting every old battle from your marriage over the kids. They need you to figure out how to grow up and start parenting them well. And I was like, I'm sitting there cheering, go judge. Thank you,
Yeah.
Yeah.
And I wish something could have gotten through to them earlier because they spent a whole lot of court time, their money, their time, and put their kids really kind of in the middle of something that I think that's one of the worst things I see happen is when a couple will not recognize they're putting the kids in the middle of things. And they would, if you asked them, they would say, no, I'm not doing that, but I'm just fighting for my rights. I'm just fighting to protect them. They're really putting the kids in the middle of it in a way that is going to bring stress and difficulty. That's one of the things that's hardest for me to sit and watch.
Yeah, that divorce is crazy. Can you explain for anybody that may watch this video? You said that they awarded something for the kids, a guardian.
A guardian ad litem. Mm-hmm.
Yeah, what is that and why would they do that? Like in what circumstances?
In circumstances, a couple different circumstances. One of the main ones is if there are any allegations whatsoever of abuse or neglect of any sort by either parent, whether it's physical abuse, abuse in how discipline's carried out, or allegations of sexual abuse, or if there, a lot of times, if there are high conflict relationships where everything is microanalyzed, everything is a fight, everything the parents can't even agree on, what baseball team is the kid going to play on next year, things like that. At some point, and it happens most frequently if there are cases where the abuse and neglect is so significant that there might be one parent or the other might lose their parental rights, especially. A guardian ad litem basically just means a guardian at law. It's a person who is appointed to represent the best interest of the children. Now, a child under 18 can't have their own lawyer. They're not able to contract for a lawyer until they're 18. But what basically you find a person, and it may be a lawyer, it may not be, but somebody who is court appointed, and their job is to interview the child, if they're age appropriate, depending on how young they are. At least interact with the child, meet the child if it's more like an infant, toddler. Talk to other caregivers, talk to mom and dad, of course, talk to grandparents, any other caregivers who are in the mix, and to kind of create a whole robust report, ideally, that presents, here's what the kid's experiencing at home, here's what the kid's experiencing at school, and advocating for the child's best interest. What the guardian says typically is very much paid attention to by the court, because we're trying to prevent, again, a child having to come and testify if they don't have to. They're giving it, and so with children who are a little bit older, it gives them a chance to have a little voice. There's somebody who listens and whose job is to not take mom's side, not take dad's side, but to actually, what would be best for this kid? Do they need to be with mom 5 nights, for school because mom's got a more stable, secure environment, better schedule, that sort of thing? Or do they need to be with dad because dad works from home and dad can make sure they get their homework done and mom's got the busier schedule? Somebody to sort through all that and be a neutral voice speaking on behalf of the kids. Sometimes when you have you have a GAL there can be a whole team of people appointed. If you get a case that's appointed to the Council for Children's Rights, then they'll have a custody advocate and a volunteer and sort of a team of people doing this assessment. In the outlying counties, here's a lawyer who's trained who's willing to do this. And that's a little bit different from, there's also a thing called a parent coordinator, which I am as well, that also is appointed in high conflict cases, not necessarily abuse and neglect, high conflict cases, to be like a referee, basically to say, I'm going to help you try to work out custody, but if you can't, the parent coordinator gets to decide things instead of having to come back before a judge every time.
And it's up to one of the attorneys to bring that person in, because a parent would not know they probably even have the right to do that. So you want to make sure you get an attorney that's tuned in enough and listening to the underlying tones, perhaps.
Yes.
That
Yes.
would say, hey, we may need to bring in these extra people. Correct?
That's right. Basically, one of the things that a lawyer can do in that situation is identify what resources are available, what arguments are available, what possibilities are available. One of the things I would say I see that is most frequently a disaster, I've got 2 or 3 of these going on now, where I'm representing one party and the other party wants to represent themselves and keeps coming to court. And like, it'd be one thing if they come to court and they listen to what the judge says and they try to, yes, sir, yes, your honor, and do what the judge says. But I've had a couple where people are coming and they're not learning the system. They're not getting a lawyer. In some cases, they could afford one, but they don't want to spend one. Or maybe they've talked to a lawyer and they didn't like what they heard, which is really dangerous. But they come and then they don't listen to the judge, or they don't learn anything through the process. And so you just keep having to have these hearings of kind of putting them in place and reminding them, hey, there's some guardrails here. There's some restrictions on what you can and can't do, and you don't get to just, defy, it's a court order now, not just what the other party wants.
Yeah. So one of your niche areas, now that you're speaking about that, is substance abuse issues or mental health, where one or both parties have these problems or issues that they're struggling with. So what advice would you give to maybe somebody who's listening who their partner is struggling with those issues? How can the person who's trying to get out of the relationship deal with that?
So you're talking about addressing at this point the person who they believe the partner has the substance abuse issue, or maybe the rage issue, or domestic violence, or whatever. Couple things. One, first and foremost, have your own care team in place. Have your own either mental health therapist, counselor, psychologist, somebody just to support you, because part of the problem with abuse and or addiction type things, and they often go together, but part of the problem is they are destabilizing. They make you wonder what reality is. They make you feel like you are crazy because you're dealing with this, and you may not be, but you are reacting to this cycle that keeps going of, oh, they love me, they're great, they're wonderful, and now they're using again, or they're raging again, or whatever it is. So have your own care first and foremost, because that will help. Number one, helps you sort through what's what, and gives you the courage and support to say, I do need to do something legally about this. This isn't just about, let's try to fix our relationship a little bit. A therapist or an outside person can help you say, hey, you notice this is not fixing, and you've tried things, and maybe you've tried counseling or something, and they're not changing. And they say they are, because again, addicts and people who are struggling with stuff can, when necessary, sometimes talk a good game, but their actions are still saying they're beholden to the addiction, they're beholden to the behaviors, and they're not going to change. So have that in place, number one. Number two, get consultation with a lawyer about your legal rights. You can file a lot of stuff by yourself. They have a self-serve center at the courthouse, which is helpful. If you have no other possibility, other resource, sure. But this is tricky stuff. When you are dealing with a person who either is in the throes of addiction or of some kind of mental illness, they are going to make it difficult. They are going to be harder than usual to get served with a lawsuit in the first place. You're trying to figure out how to file the right thing. They may start filing things, and they may file crazy stuff, and you get this crazy cluster of a case that's going to slog through the system, likely very slowly. Get a lawyer, get counsel. There are resources. In fact, if you do not have financial means, Go somewhere like, particularly if it's domestic violence is involved. Safe Alliance in Charlotte, up in Asheville, there's a great organization called Helpmate. Most counties have some kind of resource for people who are victims of abuse, and they will help actually with some of the initial filings, but they also can connect you to counsel who can help you figure out what do you need to do to protect yourself if you have assets and bank accounts and property or anything like that, how to protect that, and how to get the right kind of restraining order or whatever you might need in order to limit the ways the person can harm you. So get your own support network in place, get good legal counsel. And probably the third thing is a lot of people are daunted by the possibility of what it's going to cost an attorney, and that is an understandable concern. But not all attorneys approach that the same way. There are attorneys who will have different flexibility on funding arrangements, on what their fee arrangements are like. Most of us have the ability to have we have litigation financing available, and where there are lenders who understand the type of situation that they are lending in, and then also talk to friends and family if you are truly being harmed, abused. And chances are family and other resources have seen it or would listen to you and say, hey, what do you need? If you need to get a safe place to be, we'll help you with that. If you need somebody to watch the kids so you can go to court, so you can talk to a lawyer, they'll do that. If you need money to get a lawyer on board, at least to get started, sometimes people find out, oh, wait, you would have, if you do end up separating, you may get some spousal support. You may get child support, things like that. There may be financial remuneration that you can get that helps put you back, what you are losing by having to hire an attorney. So don't don't presume that you can't afford an attorney until you talk to one and find out what they might do.
Well, and I'm one of the sponsors of Second Saturday in Lake Norman, and that is one of probably the most often spoken from the women is
Really?
about just the cost of getting divorced. They can't afford to get divorced. They can't afford to separate for that 1 year separation because they can't afford for the two households. So it's a real problem.
Well, it's one of the dilemmas we deal with right out of the gate. If a couple needs to separate and they haven't, you have to decide who has somewhere they can live. What are those options? I mean, that's really one of the first conversations to have, and it's a difficult one. And again, of course, if you're being abused and there's actual physical harm, things like that going on, again, there are places that will take you in, that will provide you at least a temporary place to stay. And if it's a safety question, you got to get out and do that. If things have calmed down and you're not in the throes of that, then part of what happens early on is exploring what are the options, what could happen. Could you keep the house and they have to leave? How can we make that happen? There's all kinds of, different things that can be done to address that sort of thing.
I say all the time, you don't know what you don't know. So
100%.
That's why I always encourage people to do a consultation with an attorney, because it's the best hundreds of dollars that you will spend. So,
well, and a lot of times people don't realize too, particularly if it's a separation divorce situation, they may be entitled to some form of assets. A lot of people don't have ready cash, like cash sitting around in accounts. But if the other partner has a 401k account or if they have equity in their house, if they own a house together and they've owned it for a while and the market's gone up and they've made their mortgage payments and all, there may be cash available eventually that you have to just, kind of go through the rest of the separation divorce process to get to. But if they're going to have kind of a source of funding that's coming, their lawyers can work with you on that as well.
Right. I have been doing some research on this, and I know this is something that you're involved with too. Can you kind of explain therapeutic separation, what it is, and how it kind of folds into the whole divorce realm and
Sure.
how it's related?
Yes. So therapeutic separation, or sometimes in religious circles, it's called a redemptive separation. What that is when a couple is saying, and I've got a few that I'm working with in this posture now, they know they need to separate because their communication dynamic is too unhealthy. They're getting triggered too often. They're having high conflict still. They have not decided. The key is they have not decided for sure that they need to divorce. And one of them may be more inclined to separate, and the other one's like, no, why would we do that? And sometimes a counselor may be encouraging them, like, you're not going to fix this dynamic while you're still in the same house, carrying out the same duties and going about, the rest of life as normal. Particularly in the case when there has been an addiction, particularly if somebody is trying to get into recovery and to actually do what they need to do to deal with their addiction. Sometimes a period of being separate may be helpful, so they can each work on their own contributions to the unhealthy dynamic. As most counselors and addiction scientists will talk about, even if there's only one person who's actually addicted to a substance, the other partner has a role to play in that dance. They may have enabled, they may have served in a certain function as a trigger or catalyst for the addict. And so sometimes a time apart can help disentangle some of those old ways of relating. Even when somebody's committed to sobriety, part of the problem with being committed to sobriety is you're sober and you have to deal with the actual pain and things that are there that were making you want to use and act out. And so a therapeutic separation is a couple of saying we need some space, but we don't want to start the whole works of we're definitely divorcing. We actually want to provide for maybe 3 months, maybe 6 months. That's one of the things you decide from the start. How much space do we need? What does space look like? It's very different from an ordinary separation, a legal separation that's purely legal, because in that situation, right out of the gate, most of the energy is on support and finances and all that. And we do address finances in a therapeutic separation, but it's from a short-term perspective. We will identify and categorize and know what assets and debts they have. We'll get the financial picture, but we're not yet dividing anything up. We're not saying who's going to end up with what. We look at, if you do the separation, who's going to move out, where are they going to live, what are the financial arrangements going to be, and more specifically, when are we going to, what is it going to look like to talk about the relationship? If we're saying we want the relationship to improve, the good thing about somebody who are initiating separation is they're calling the question saying, hey, look, however we've been doing this is not sustainable, and I can't keep doing it like this. I believe there's a chance that we could, if we both work on our stuff, and I love it. It's better when people are both saying he needs to fix his stuff and I'm good. I like it when people can own. It's usually the dynamic, the unhealthy communication dynamic is usually, to some degree both ways. Not saying you're as bad as the addict or anything like that, but you can learn ways to communicate better. So anyway, therapeutic separation, that's what we would address. Are we going to, if we, one of us moves out, when are we going to talk? Are we going to text? If we have kids, we're obviously going to arrange for what is visitation going to look like. Again, not trying to set a pattern that's all for the future, but rather for the next 3 months, 6 months. What are we going to tell the kids as we're doing this? What's our messaging to them is really important, to present a united front and say, especially depending on what age they are, how are we going to communicate to say, this is what we're doing, this is why we're doing it, here's what we'll tell you, here's questions that you may have that we'll answer, here's questions that we can't answer right now. And again, you tailor that to the age and stage the kids are. And the point of it is to come up with an orderly separation so that you set expectations. And so, hey, we are gonna have date nights. We're gonna have like a date night every week, or we are gonna talk about our relationship, but only with our counselor until we decide we both feel safe enough to have a conversation. So that means when we're talking about who's picking up the kids and who's picking up groceries or something, we don't slide into, yeah, but you never do anything, and yeah, but you're bad. We decide when, because that's part of, again, healing and therapy, is learning to have boundaried conversations. And like, hey, it's time for a relationship conversation, and that's a different kind of conversation than these other things. So it's giving ground rules, and it's really trying to think, to be really thoughtful about what are the next 3 to 6 months going to look like. It can initiate a legal separation, and sometimes people want that, like, let's start the clock on the 1 year before we can divorce. We do want that clock running. Let's fix that date for evaluation purposes. Sometimes people do a therapeutic separation and say, let's don't call this illegal. You have that choice. You can do that. technically, if somebody moves out with intent not to resume the marriage, it is a legal separation. But if you say, actually, I'm intending to stay in the marriage unless and until XYZ happens. So you talk a lot about in recovery too, about if somebody's in recovery, you talk about benchmarks, sobriety, seeing a counselor, us seeing a counselor together. You're working through all that. So it's got that more therapeutic piece of it than just
that was going to be one of my questions. Follow-up questions was if they are separating with the intentions of perhaps reconciliation, would that time apart go towards their 1 year? But it could. It could. Right?
Yes. Okay. And you need to address it expressly one way or the other. If they agree we're not starting the clock, you could do that. The default is, hey, it starts the clock. It is a legal separation unless you say otherwise.
Exactly. Well,
So,
the thing that brought,
if you don't mind me jumping in.
No.
So I find this very interesting because maybe this is just my interpretation, but the 1 year separation, we're in the Bible Belt of North Carolina. So, from my understanding and my interpretation, the point of the 1 year separation is to make sure you want to be divorced. And I have never heard of this therapeutic separation, but I really, really love the idea. And I can see where, the 1 year separation rule has come in, but a lot of people use that as their equitable distribution timeframe. So all that being said, this seems like something that really falls into collaborative law, which our listeners will hear a lot about because Lori and I are both huge fans of it.
Sure.
But how do you see this coming up in like a more litigative divorce, or do people only do that in collaborative? And if you also want to kind of talk about collaborative, this would be a good
Yeah. So I want to be careful to draw the lines carefully here. A therapeutic separation can only happen, and this is a similarity to collaborative divorce in a way, can only happen if both parties agree, hey, we're doing this. We both agree there's still a chance, even if it's a small chance. I've got one going right now, and the wife is like, I don't know. I mean, we've been at this a while. We separated once before. I'm skeptical, but she hasn't closed the door. And she said, I'm open to it. And one of the conversations we're going to have is what kind of change do you need to see happen in him for you to feel comfortable continuing the relationship? And then helping him to see, are you hearing this? Do you understand what she's looking for? Are you willing to give her that? Are you willing to try that? So the outcomes of therapeutic separation could be they work their plan. They each do the individual healing. If they do couples counseling, whatever, and it works. And then they just go back to being married. And so there's no court process ever. And there's nothing legally on file with the court or anything like that. People who are in the mindset to try a therapeutic separation are usually going to therefore be less in a fear mode most of the time. They're less contentious, less like, well, wait a minute, you can't have the kids, I get the kids. And so I would say if a therapeutic separation does not work, you have the advantage of it. At least they know they gave it a try. They had some professional help in doing that. And they could transition then into, well, we've been educating ourselves about finances. We've got kind of a working plan on, has this been working for how we exchange the kids? You're less likely to have, well, now we're all bets are off. You're more likely to set up for, well, we have given it our best shot. Now, since we're going to, split and it's amicable, let's either have a collaborative lawyers help us and do a collaborative process, which I'll talk about in a minute, or go straight to mediation. Or sometimes they're like, hey, we've kind of worked it out. We kind of have and maybe just they sit and scribble down on a piece of paper, here's what will work. One of them takes it to the lawyer to write up as a formal separation agreement. It could be when it ends, if it ends poorly. Let's say husband's an addict. I'll just assume that, and wife has given him enough chances, and he's not getting better, and he is becoming, he's still active in his addiction and becoming more destructive. Then the wife might have to go, well, I'm ending this therapeutic aspect of this. We are still separated. If you want to make a deal, we can. Otherwise, I'm going to start filing things in court to make sure that I protect my interests. And you can still have a softer launch of it, or if he's really acting out or some incident with kids, then you may have to escalate quickly. but it does not, the two are really considered separate because when you start talking about collaborative versus litigation, mediation, you're talking about dispute resolution, processes. Therapeutic separation is a little bit different animal of its own because it is more driven by the relationship. And the separation piece of it that has a legal feel to it is, we make sure everybody's needs are provided for, and the kids are, we know where they're going to be. If we need to be formal about that, we can. Sometimes a counselor will be sort of running the therapeutic separation. Sometimes it can be a lawyer, ideally a lawyer trained as a mediator, really, like me. And so, yeah, it doesn't necessarily dictate or presuppose any dispute resolution process. Does that make sense?
Mm-hmm.
Yeah, definitely. It seems like you have a perfect marriage of those two areas of focus, because if somebody's willing to do that therapeutic separation and it didn't work out, it seems like they would go to the
It's like a
collaborative.
perfect segue, right?
Yeah,
Right.
exactly.
Mm-hmm.
I have it set up right now with one couple I'm working with where basically they've signed an agreement. They've hired me essentially as a mediator. And the first thing I'm mediating is the terms of their therapeutic separation and how long are they going to try that? Because you have to kind of put an end time on it for one partner's sake. Like, let's try this for 6 months, but if I still don't see change, then we've got to name it, call it, and go the other direction. And it's a great way to use that 1 year. However, we got to have that year and whatever the thinking behind it, which seems, a mystery and antiquated. We could all have commentary on, but I don't know if it's going to change anytime soon, but it is a long time. But if there's uncertainty, a great way, since you can't make it happen super fast, if there is uncertainty, if there's hope, if somebody really wants to give the other party a chance to change, is willing to do their work to change, it's a great use of that time. And you're not, if you've already initiated a legal separation, you're not losing anything.
Right.
Your time is still run, and then you're like, well, it didn't work. You're not starting, because a lot of people are like, I don't want to go through a bunch of trying to make it work out, and then we decide it doesn't, and now I start the clock,
Right.
and we're
Right.
behind. And so it helps, to bring some formality to it, helps avoid that problem.
Right. Well, and kind of what brought you and I together the first time was kind of our love of collaborative divorce.
Yes.
Because even though I am not an attorney, I'm a realtor that does divorce real estate. I went through the collaborative divorce training because
Yes.
one, I just find it fascinating. Two, I think it's such a great option for not all, but for people, and a lot of people don't know about it. It's really big on the West Coast. In
Yes.
California, collaborative divorce is like a big thing.
Ingrained in their culture. Yeah.
Kind of making its way this way, but slowly. So kind of tell people, what collaborative is and who can do it and why you should do it and all the good stuff about it.
Yes, absolutely. So, collaborative law or collaborative process is the reason I'm a family lawyer now. In 2016, when I had been teaching law school for a while, and I left the law school I was teaching to return to private practice. I was trying to figure out what kind of lawyer I wanted to be, and I heard about collaborative law from some people who are trying to adapt it. It started in family law circles in about 1991. It started up in Minnesota, and has spread to all the other states. And basically, it is its own dispute resolution process. It's not just, we're going to cooperate, we're going to collaborate. It is actually an independent process, and it does require training. And it's a whole different mode of addressing all the issues that you have to talk about in a separation and divorce. In a collaborative divorce, the couple, and on the front end, as soon as they identify, hey, we need to separate, maybe they've been separated for a while, we're going to divorce, or when they're first separating, they can, and I encourage people to talk with lawyers who are trained in collaborative and other methods, because as collaborative lawyers, we're ethically required to make sure you know about all your dispute resolution options, and we will. People who are used to conventional divorce, traditional divorce, and litigation don't have to tell you about collaborative. They might not. But make sure you understand it, because if both parties basically need to agree, we don't want to go to court. We don't want to let a judge take the power of deciding what happens with our family. We don't want to be on a court's timetable of telling us when there will be hearings and when we'll make decisions, which even if you're trying to work it out Still, sometimes if you get started in the system and you get the lawyers started firing shots at each other and trying to, protect your interest and trench for a battle, then even if you want to try to negotiate and work it out, you sort of lose the ability to do that, or it will happen kind of on the timetables driven by, well, when's your next hearing coming up? When's your next appearing? What are the deadlines by the court? If you want to seize control of that process from the start, then what a couple in that circumstance does is you can each hire a collaborative lawyer. And I kind of like to compare it to mediation. And I'll say quickly what mediation is for your listeners. Mediation is when you hire one person who's a professional to serve as a neutral mediator. They don't work for either husband or wife. They are there kind of like a counselor. It's a very similar role, but to help you negotiate the terms of all the issues that you need. You can handle anything: child custody, child support, spousal support, alimony, distribution of assets. All of that can be handled by agreement. The two limitations, and I'm a certified mediator as well, the two limitations that I have in working with a couple as a mediator is, number one, a mediator is not allowed to give legal advice, which means I can describe, here are the decisions you need to make. I can encourage you all to, negotiate and get together. But if either of you says, is this a good deal? Should I do this? Would I come out better in court? A mediator really can't answer that question. I can't give legal advice that says you have rights, you should do this, you should do that. I can just set up the conversation. These are the issues you need to discuss. They discuss it. The second, and a lot of people really find they need that. They need somebody who's just looking at the case from their perspective to say, what options do I have? What are the good ones? What are the bad ones? The other limitation a mediator has as a mediator in North Carolina, pursuant to the rules of the Dispute Resolution Commission of the North Carolina State Bar, we can't draft a settlement agreement for a couple. We're not allowed to do it. And so what has to happen if I mediate a case and at the end of it, they have reached a term sheet, they've reached basic terms of agreement, I have to say then, okay, great. One of you take this to a lawyer, and I keep a list of lawyers who will do this, low cost. Hire this lawyer to draft the agreement up and say, look, it's been negotiated, it's been mediated, here it is. They draw it up for that lawyer, say it's the wife, and then wife presents that agreement to husband. Husband can review it with a lawyer, or he can choose not to make sure that it meets what he agreed to, and then they can sign their agreements and process the paperwork, etc. So collaborative kind of is one way of solving those two problems. It's essentially like hiring two mediators instead of one, but each collaborative lawyer works for their own party, and so they can give them legal advice, and they can say, here are your options. However, collaborative lawyers are committed to staying out of court. In the pure form of collaborative, you actually sign an agreement that says, this is how we're going to operate. We're going to share all our information. We're going to be respectful. We're going to not fight the battles of the past. We're going to pay attention to that people have emotional reactions and we are feeling things. It's not, just for people who they don't have any feelings. They're just kind of cool and everything separating, going their separate ways and everybody's chill. No, we know that we're emotional and we are having difficulties with this, but we want to contain that. And we don't want to go unleash that on the court system and have the court system decide for us. We instead want lawyers who are trained in how to work in that environment and not pour gasoline on the fire, and how to keep us at the table even when we sometimes don't feel like we want to be there. But we know we're committing on the front end. If we spend all our money, the resource that we have on a court battle, we're all losing, and we don't want to do that. And the court, and in the pure form, again, the lawyers will sign this agreement with you, and it says this is the key, and this is the thing that people have some difficulty with. If the process does not work, and I'll come back to that as to how often that's ever the case, but if the process doesn't work, those lawyers bow out. You can still go to court and have all your rights, but you start over with a new lawyer. The reason we do that is two important purposes. One, you know that the lawyer you're working with as a collaborative lawyer has one goal in mind, helping you get this resolved. And so does the other lawyer. They're not trying to out-trick each other, outflank each other. There's no gotcha moments. There's no, haha, I know this, you don't know that. It's all, how do we keep everybody focused on the future and making the best decisions they can with where they are now. Second reason we do that is because if somebody gets weary with the process and they want to bail, they got something extra to think about. You really want to go and start all over and start that process. And again, go back to where you're ceding control. That's the thing I urge people to think about. They don't realize when you go the litigation route right out of the gate, you're ceding control of your case. Doesn't feel like it because you got a lawyer saying, I'm going to go with you, I'm going to fight with you, but they can't control the case any more than any of the rest of us can. Court docket controls it, the rules control it. So let me finish that thought. The purest form of collaborative then is both sides commit to that. And only when it doesn't work do they end up going to court. The statistics are that 81% of the time it's successful. 81% of the time, at least in our local group, and that I think matches with national stats, and maybe better in California, I don't know, but almost never does it break down and you have to go to court. Partly because even after you've collaborated for a while, and if you're getting stuck, you can hire a mediator at that point in time to come in and say, hey, we've got 80% of it resolved. This last 10% is killing us. This last 20% is killing us. Forget my math. The other thing we do in collaborative is you bring in neutrals. You bring in experts like you guys to come in and be advisors, not battle of advisor expert versus battling the other expert, but rather somebody like you guys come in and says, okay, like Pam, let me tell you what mortgage options are there and how to get them. Let me talk to you about if you need to list and sell, what do you need to do in this particular market, in this environment? How do we navigate some of those places that are going to be flashpoints most efficiently? And so the collaborative process allows you to assemble a team of experts. You may have a child welfare expert involved to say what would be the best schedule for the kids. It's a whole different problem-solving approach, and it is a recognized legal process as an alternative to mediation. So I just like to make sure people understand and know about it. So I love that folks like you are getting trained in it too.
Yeah. Several things going through my head. One, let's say you get 80% through the process, and for whatever reason they can't do it, or one of them is just like, I'm done with this, I'm ready to go to court, and so they have to drop you guys. All of that work of that 80% can still be handed over to new attorneys, though. Is that correct?
Yes, because a lot of what you've done is you've exchanged the necessary documents and information. That's where a lot of the litigation process gets bogged down.
Because it seems scary to think you have to drop your attorney, but you don't have to drop all the work that up to that point. I feel like sometimes that's not well explained, or
I think that's right. Yeah.
That that's a reason, like, well, you don't want to have to do this because this is what may happen, not thinking, but all of that hard work can just be handed over. That next attorney can be brought up on the case very quickly.
That's right. It's an easy handoff, especially these days with, all our documents, records are digitized. It's easy to hand off the file. And the other thing is this. You've learned in that 80% process, even if it stalls out, you've learned about what's important to the other side. Because in collaborative, we talk about negotiating on the basis of interests, not positions. So it's not, I get entrenched, I say, my client will never do this, and we're not doing anything more than that, and nobody will make us. You talk about, hey, what are we trying to accomplish in this case? What interest does husband have? What interest does wife have? And let's look at where they overlap, because they forget in all the conflict, they forget you all have some interests that are the same, such as neither of us want to pay $20,000, $30,000, $50,000 to a lawyer and not have that money, right? If we can both save that money, and we don't want another person, a judge who hears about our case for a day or two, deciding the fate of our family, that's a common interest, right?
That's the biggest thing for me right there.
Yeah. And then you look for, how do we prioritize among the other interests? What is important to you about having this particular custody schedule or having this much alimony? I've got a case right now, a collaborative case going on, and each party has sort of had their interest, and we came in and one party wanted to go a lot faster than the other, and the other was, it's interesting. Different pieces of it. One of them wanted to be fast on one aspect of it, but slow on everything else. The other one wanted to be fast on other stuff, and then everything changed when they thought they had an offer actually on their house without putting on the market, Laura. You can appreciate that. That's sort of the one who was waiting to sell and didn't want to sell anytime soon said, wait a minute, somebody's here and I don't have to fix anything up. They're going to make a as-is cash offer. They're like, well, that'll change my timetable and everything. And so there was all this energy that direction. Then that offer fell through, but then they're like, well, let's go ahead and list it anyway. So they start doing all that. And then one of them had a health issue. and as it was going to have a health procedure that was going to be pretty substantial, and they might be rendered, unconscious, incapacitated. It could be fatal, that sort of thing. All of a sudden, faster, sooner became more important. And so one of the conversations that we were helping to have is, okay, now that certainty faster has risen on the priority list, and both of them are like, yeah, we need to get something signed, get something, I want this kind of behind us. That's great. What are you willing to sort of let go of being as exacting about? Like if you want a line by line, item by item perfection of balancing and all the cash, transactions, all this stuff, that ain't gonna happen fast. It's sort of like, Laura, you've probably heard in real estate where if you're talking to a builder and somebody's building a house says they want it built fast and cheap and perfectly and well. And a good builder is going to say, you can pick two of those and hope you get those two. But if you want it fast, it's not going to be cheap and it might not be well. If you want it done well, it might not be cheap and it ain't going to be fast. You got to choose the ones that you want and balance those out. And that's a lot of what we do in collaborating that I do as a mediator, is helping people prioritize. Nobody's going to get everything they want. Rarely does that happen. And those who think they might get it, I will get everything from the court. You're going to at least incur cost, fees, time, and stress to get that ideal result that you might think exists. So it by definition, it isn't ideal anymore. If you are going to have to spend substantial money, time, and stress to do it, so therefore you need to factor that in. And so I love that collaborative we're honest about those limitations and those challenges, and we put them in a better framework for empowering the couple to make a decision rather than, and really if collaborative works, the lawyers sort of almost fade into the background and the couple's talking more because we've been modeling for them, here's how to disagree without being a jerk about it, which is probably my favorite part.
Yeah. And another thing, I was so excited when I was able to attend a continuing legal education class that you taught. And this is kind of another area that you kind of are involved with, because a lot of people buy property together and are not married, right?
Yes, that's right.
And so they're not really getting a divorce because they're not married.
Not
it's
at
not
all.
the solution
That's right.
of the marriage, but they still have this property that they need to sell and, other things. That's something else. If someone listening to this finds themselves in that particular situation, that's something you can help with too, right?
Yes, I've got a few matters going on that like that right now. And if you recall, one of the points of that whole workshop was if people are not married, but they've lived together, and if they bought property, if they've started a business, which has often happened, or they've been involved in each other's businesses, or if either of them start a business during the relationship and the other one participated, may have had ownership interest, who knows? I've had several where a couple invested in real estate and they formed an LLC just to buy a piece of real estate that they were investing in while they were living together. The problem is there is none of the protection of Chapter 50 of the North Carolina statutes that governs divorce and separation. There is no equitable distribution, which presumes that, marital assets are divided 50-50, all of that. There's no alimony, spousal support. There's no, you still have custody and child support. Yes, if you have kids in common, it doesn't matter whether you're married or not. But for the financial aspects of it, you are not going to domestic court if you have those cases. You're going to some combination of district court, superior court, maybe even business court, which we have a business court in North Carolina that handles intra-company disputes between the owners of companies. You could be going to 2 or 3 different forums to battle these things out. If you both, for example, I've got a case right now I represent father, mother. They've been separated. Their relationship ended a long time ago. They've been co-parenting, but he put her name on the house, on the deed to the house. He gave her an interest in the house, even though they never married. And as I understand, she never paid the down payment. She never paid any mortgage payments, but she is listed as an owner. She's filed a petition to sell that house in lieu of a partition because you can't split a house in half. and she's a co-owner, and she's going to get something. Determining what she gets is an absolute nightmare. Because it gets into, let's say somebody did contribute to the mortgage, they did contribute down payment, they get to say, hey, I want that money back. And should they get that money back? Well, I did this, I did that. And you're doing it in front with all the energy of a breakup in front of courts that are not as used to that as the family courts. And there's just so many different places you can go with it. So I'm a big proponent of folks like that when they are splitting up and they're realizing we have to disentangle. Get legal counsel for sure, but you need to talk to somebody more than just a family lawyer. They need to have some background in superior court litigation, practice before the clerk of a superior court for partition sales, things like that.
Which you do, right?
Yes, which I've done all of that, and I've done enough of it to know if those folks can collaborate, and they can. That's the thing. Collaborative law is available for everybody. There now is collaborative practice for civil cases, for non-divorce and custody type cases. Yes, that happened in 2018. I think the statute was passed, which is, again, what lured me in, because I have a real estate and business litigation background. I'm like, oh, I want to do that. I want to help people collaborate to resolve business cases and all. And it's a slow build in that market, but where I think is an unexplored territory that I've seen have some success already. Actually, a couple of us have handled a cohabitation breakup where they had children. Husband had put he's an artisan. He was a craftsman of some sort, and so he had an LLC for that purpose. And it was him. He was the artisan, the craftsman, but he had people who kind of worked for him, marketing and sales, administrative and stuff. And the girlfriend had worked for him some, but he put the business in her name because he wanted to qualify for minority woman-owned business credits. Okay? So when they go to break up,
those things come back and bite you, right?
Yes, when we break up, I'd say, hey, dude, she owns your business. Like, it's not like y'all have something that, like, she actually owns it all, but you're the only one who can run it. And so we actually had to get creative in figuring out, because there wasn't going to be, she's going to get child support, but there wasn't going to be spouse support. But we came up with something where he could buy the business back from her over time, and therefore it's like he was making support payments. Really.
Right.
Which he really wasn't, but it made a lot of sense in that circumstance. And so when they've gotten entangled together, I've handled numerous cases like this. A collaborative approach or a mediation first approach is key, because the procedural back and forth wrangling could consume months, maybe years, and lots of time, energy, and money.
Honey, yeah. So the moral of that story is, if you're not married, do some kind of agreement, at least if you have, although it's not the be all end all. I had one of the cases I talked about in the CLE that you attended, where this couple had purchased property on an island off the coast of North Carolina, one of the Emerald Isles or the Outer Banks, and they had bought this property for purposes of selling it or renting it as an Airbnb and holding retreats and things like that. And they wrote up a deal where one of them owned 2/3 and the other owned 1/3. But when their relationship blew up, all that agreement blew to hell too. Like, they basically were like, well, we never followed that anyway. Like, they wrote something up. They were doing the right thing, but it doesn't save you. It just means here's a contract that also has to be litigated, which is better than having no contract, but not by much. Unfortunately, at least because it's like a lot of contracts. Yeah, we signed that thing, so we'd have something. Our bank wanted to see it, but then we never read it again, and we didn't follow the provisions that came up for when we have disputes and all this stuff. And so it's still just a absolute mess to disentangle. And theirs got magnified, but they had deadlines for having to refinance a loan. It just got complicated 6 ways to Sunday. I mean, yeah, I remember that. And it was just like the hole kept getting deeper and deeper and deeper until you feel like you're just suffocating. I mean, honestly, just divorce as a whole is it really is just so an ugly.
Well, and any breakup when you've been invested in somebody else's life. And you have
I've
done
been
life
there.
together.
I know. I'm speaking from experience. And mine even went well. I wish I'd known about collaborative at the time. But anyway.
Well, yes, we're glad we're trying to get the word out so more people know about it, but especially for cohabiting couples, I think it's their only shot really to try to keep it out of court, out of multiple courts, and to sit and you got to have it's basically a business decision.
Mm.
But I've got divorce cases that are like that as well, where they have agreed the marriage is ending, we are done. But I've got several cases now where they've invested together in a dozen or more properties that they've been owning and renting, and they're trying to divide up, who gets which ones, and that is an absolute, mess.
Yeah,
That's so much better to negotiate than to ask a judge to just divide stuff up.
exactly. Exactly.
Well, Chris, thank you so much for sharing all of this with us. It's been really enlightening for me, and I think Lori too. We both
Mm.
are around this all the time, and it's always really humbling to learn how much we don't know. When we hear all these little nuggets of information. So thank you so much for sharing all of that with us.
Well,
Um,
thank you. I want to say I'm learning from Lori as well, just as we've had conversations about all the different things as a certified divorce real estate professional that she is thinking of when we were sitting there talking about how she operates in a case and tries to set up protocols and procedures for how to communicate, even about little decisions and stuff. I'm like, oh my gosh, that would be so helpful because it's all kinds of things that people don't know is coming. I'll say this real quick too, Lori. I was talking with the woman at Illumini who trained you,
Hmm.
and she was talking about CDREs haven't always found as welcome a grounds in collaborative, in her experience. And we were talking through one of the issues of it. And I've got this going on in a case right now where the couple who's doing collaborative says, "Oh, well, we both know Sally Sue. Sally Sue's our friend who sold us our house, so let's just get her to be the realtor." Okay, if they're getting along and they all still trust each other, that's fine. But unfortunately, Sally Sue finds herself put in a bind sometimes when they're not seeing things the same way. They don't even agree on whether, the recommendations of should we redo those countertops, or paint that or
Yeah.
whatever. And not having training there, I think, is making, Sally Sue go, what in the heck did I step into?
Yeah.
So I appreciate learning even just how you can anticipate some of those things and try to get
Mm.
out in front of them. And I imagine it's similar for you, Pam,
mhm.
with
Hmm.
identifying there's going to be pitfalls for mortgage lending when
Hmm.
somebody's trying to establish an income and they haven't had one, or they're trying to establish, yes, I know that looks like a lot, but I'm getting money from him, whatever.
Yeah.
She really is a miracle worker when it comes to divorce mortgages. I think there are a lot of people in very different situations that could see where you would be beneficial representing them, from collaborative to substance abuse to, there's a lot of things that you kind of hone in on that a lot of family law attorneys do not. Just quickly before we hop
Yeah,
off, if somebody wants what should somebody bring to you if they want to come to you for a consultation? Like how should they already be prepared
sure.
for to come to meet with you?
So one things I'm gonna lead with in an initial consultation. I'm gonna lead with the process conversation. I'm gonna hear about what's brought you to where you are.
Mhm.
Why are you separating? How did you get here? I want to hear that story, but I'm also going to spend time trying to figure out what is the process that fits your situation. Some people, and you say, golly, yeah, we need to get to court. Some people come to me and they've already been named in a lawsuit by the other party. And so okay, we're going to court at least to start with, but how are we going to posture this? And how are we going to possibly, even though it's going to court, we can still steer it in a resolution direction. And the biggest factor in that is going to be who's on the other side. Who does the other party hire for a lawyer makes the greatest difference, bar none, of is it going to be a smoother process to negotiate and navigate through, or there are certain names I see on this time like Katie bar the door. It's going to be ugly. I'm sorry, no matter,
Really? That's
or they're
interesting.
going to try to make it ugly, and we may resist that, and we have to have a different strategy. We have to be ready for the fight, but
Hmm.
also holding the door open to, do we have to do this? Is there another way to do it? So I would say the first thing is I've got some resources on my website that I encourage people to watch, ideally before we get together, where I go through this discussion of the different processes of mediation, collaboration, litigation. I kind of
Okay.
compare and contrast them all. I
Hmm.
also have a section, a video that describes here are the legal issues that you may have heard something about that that here's the ones that have to be determined, here's ones that don't, kind of triaging the urgency of that. And so, educate yourself, which people are going to be doing, but I've got some particular resources that it's helpful. It speeds up. We can get into things. If they've already watched that, then we can jump into the process conversation quicker. The other thing is start getting your financial picture. And that's going to be different for different people. Some people I work with, like, I don't know, he's always handled the finances, and I'm just getting trickles here and there. I've taken a screenshot here and there, stuff like that. Other people are very, very astute and very dialed in, like, oh, I know what we have better than the other side does. But whatever it is, start putting your financial house in order and getting an understanding of what is our future going to be. It makes a big difference if the spouse who has been making no money or is making less money, what is their earning potential? Yes, they will have a chance to get support from the other person, but will it be enough? I encourage people to start exploring, where you're going to live. I can initiate that conversation, but if you're going to move out or they're going to move out, what are the options? Sometimes that's already happened. Sometimes it hasn't. If people come in like, well, I'm keeping the house. Okay, maybe. We have to look at the whole picture of everything. But if you want to keep the house, talk to somebody like Pam early on to start looking at, hey, if I were to go out, first of all, is this mortgage, if you're both on the mortgage, then you got to do something with the other person's, name being on the mortgage there as an obligor. Most banks, tell me if I'm wrong, Pam, aren't just going to say, oh, you got divorced, I'll just let one of you off. Mm-hmm. It doesn't usually work that way. There's rare occasions I've seen it be able to happen, but typically you're looking at a refinance if you need to buy the other person's interest out. Or we can, again, collaborative and mediation, we can get clever about, hey, just because you have to buy the other person their equity out doesn't mean you have to do it right away. You might be able to do it over time. But if there is going to have to be a one-time buyout, can you qualify for, the party who wants to keep the property, can they qualify for a new loan? And for enough to refinance the existing loan and buy out the other person's half the equity? Start having that conversation early. Start actually exploring that with somebody. Because then you'll be ahead of the game. We're always going to, want to ask that. If you want to keep the house, is there a financially feasible plan for doing it? Mm-hmm. And then lastly, again, I can't emphasize enough, have your own support network. Even if you haven't been in counseling before, it would not hurt to get some now. You're making a major life transition, something that you had hoped was going to be your forever, happily ever after is not. You're going through something that is traumatic. A counselor can help you make sense of that, be a support and a source of guidance or something, religious support, friend support, something, and not just people whispering, you're saying, take him for everything, or you better protect your butt and, lawyer up quick and squash her, not those people. People who can help you have, what is the best approach given your scenario, given what you're dealing with. Because a lot of people find themselves stuck in the system waiting on a court hearing, and they wouldn't need one if they would pause and do some of these things and figure out, what am I dealing with on the other side? How is there a way to have somebody help us have a productive conversation now that we are ending it?
Perfect.
Yeah, another piece of that too is your friends who want you to get through this and all of that. Unless you're friends with therapists and counselors, they're not professionals who can help you,
right,
get through this in the best way possible. And they're probably going to get tired of hearing you complain about your ex-to-be. So,
well, and they have their own stories too. They are, usually informed by something they've experienced, and that makes people sometimes a little bit jaded. And I don't blame them. Look, people have had bad experiences in the court system. Some people have had bad experiences with collaborative. I think it's pretty rare. But it's not for everybody. But get some good professional guidance, and the connection point, whether you can work with this lawyer, this real estate professional, this counselor, whatever. You got to have enough time to get to know them to know they're in your corner and they're there for you and they're bringing their expertise. And if they're there for you, it'll be helpful in those hard times when they have to say, hey, I got some hard news. We can't do this, or you're not going to be able to get this. You want to know somebody is at least they're trying and they're looking for ways to get you to what you need, so that you listen when they say, yeah, it doesn't work exactly like that. I can't prevent X, Y, Z from happening. If you already are feeling sort of not listened to and not cared for, then when the tough news and the tough decisions come, it's going to make it that much harder.
Yeah. Well, we're going to put all of your contact information on here. I know you've got a podcast called Surviving Saturday. Where can people find that and listen to more of you if they want?
Oh, that's a whole different podcast. That is, my wife is a mental health counselor, and she and I sometimes work with couples on trying to work through conflict in marriage, trying to see if you can navigate those places where you're really stuck, and work through them and find a way to understand and interact with each other differently. And so that's what that podcast is about. It's on Apple Podcasts, Spotify, all those places. Just Google Surviving Saturday Podcast. If you have some hope or want to have some hope, we tell our story kind of we've married 31 years now, but there was a point about 13 years in where the wheels just fell off and we were in a really tight spot. There was a lot of stuff from our families of origin that we hadn't really understood or dealt with. And we were just kind of, had fixed everything external we could, and we're still left with our own difficult dynamic. And so we talk a little bit about just what made the difference for us during that time frame when it was just really, fraught and challenging. And we try to, provide a little hope and encouragement to folks who are in that spot. And it's some of the work I really enjoy doing as well. That really overlaps with that therapeutic separation type stuff. How can we fix these dynamics? Let's admit what we've done so far hasn't worked. And we've certainly navigated that route some. So thank you for mentioning
I love that.
Well, thank you so much for being here today. We really appreciate it so much.
Well, thanks so much for letting me be one of your earliest guests here. I feel honored. I'm excited about what you guys are going to do. Your energy is so encouraging, and the fact that you have cared enough to get involved and learn about collaborative, that spirit is going to be so helpful in helping people navigate this difficult transition. It's good for them to have good guides like you guys.
All right. Well, thanks so much.
Thanks, Chris.
This podcast is for informational and entertainment purposes only. Information contained herein is not legal advice. If you need legal advice, please seek an attorney.